As a probate attorney, I oftentimes will get questions from people concerning wills and what can be done when they believe that the will that gets presented to the court is not the actual will of the person that passed away. Either it was a forgery of some sort, or there was some sort of trickery that was involved with getting the person to sign the will that ultimately gets presented to the court. Well, number one, you cannot challenge a will before the person passes away. If the person is still alive, then it's not a ripe claim because they still have the ability to change their will. Therefore, you can't necessarily challenge it while they're still alive. But after the person passes away, you then start looking into whether or not you are in the class of people who should be able to complain about the will. Either you are some sort of heir at law, meaning that you hold a certain relationship to the person from a legal standpoint, which is normally determined by your blood relationship. So you're a son, you're a surviving spouse, or something like that. Or alternatively, you may be somebody that was in a prior will and then comes along a trickster who somehow manipulates the decedent into changing their will. Then you may be able to actually file some sort of claim with the court and try and challenge the will. You have to be in the class of people or the type of person that has the ability to say something because you are affected by the outcome. If you're not affected by the outcome, you won't be able to challenge the will. So if you're just a neighbor and you believe that the decedent told you, well, you know what, Bob, I'm going to leave you in my will and I'm going to sign this over to you and I'm going to do that. But there never is a will that you have an opportunity to see and nobody's ever seen this will. You're just going based on what your friend told you. Well, that's not a circumstance where you would be able to file some sort of lawsuit to challenge a will when another will pops up that it doesn't mention you at all. So those are just a few things to take into consideration if you are considering whether or not you should challenge a person's will. And probably the most important thing after you get past whether or not you are in the class of people that stand the ability or that have standing, you will then start looking at, is it worth it? Based on what it is that you stand to gain, based on what it's going to potentially cost you as far as a financial investment, because litigation and fighting in court, it tends to be a bit pricey. There's also a certain emotional investment and a certain time investment that you have to put into these types of cases, and you have to make a decision as to whether or not it's worth it. This is attorney Marcus Sermons from Sermons Law, and this has been another episode of Interesting Lawyer Stuff.